Thank you, Madam Chair, and I appreciated your comments, Madam Chair, earlier in the hearing that you wanted to make sure we were adequately funding the Securities and Exchange Commission because they were the cop on the beat. I just want to note for the record that the chairwoman is for funding the police, and just appreciate that. Um, uh, Mr. Chairman, Chairman Gensler, thank you for appearing before us, and I appreciate our conversations about the importance of materiality with respect to climate risk disclosure. Earlier this year, you and the Commission issued a request for information on climate risk disclosure. A common theme among respondents to that RFI was the importance of maintaining this long-held materiality threshold. I agree with these suggestions. Materiality must be preserved. But I want to point out that materiality is determined by investors' need for that information to make informed capital allocation decisions. It is not in order to satisfy the leadership of some large institutional investors who are not necessarily aligned with retail investors in terms of their demand to name and shame companies or bias the market against certain politically unfavored industries. That is the difference between the standard of materiality versus what some large institutional investors demand. How do you plan to ensure that the SEC climate disclosure rule maintains the threshold of materiality and does not burden investors and issuers with an avalanche of extraneous information?
Well, I share your view that it's about investor demand, whether it's somebody buying 50 shares of stock or a fractional share even, or the large asset managers and pension fund managers that are investors as well. The pension fund managers, the asset managers are representing the rest of us, representing the public, and I share your point there. But
how well do you think they represent the rest of us, and how well do you think that proxy process actually accurately reflects the demands and the wishes and the desires of those retail investors?
Well, our job at the SEC is to make sure that it represents it through what's called the duty of care, the duty of loyalty, the 1940, the two laws passed back in 1940 that are really important that investment managers are representing through their fiduciary duties their public.
Yeah, and the reason why I asked that is because as we discussed, as I talked to the investment advisors and broker dealers in my district, ESG is a very low priority of most retail investors. Retail investors care about returns. And what troubles me, and I want to ask you if you agree with this, the analysis that's a public record, that many of these ESG funds have fees that are 43% higher than non-ESG funds and cut into those retail investor returns. Does that trouble you?
Well, I think that two parts of that. One is I have asked staff to make sure that fund managers that are claiming to be green or sustainable or climate free or so, what stands behind that we should put out some rules on that. And if my fellow commissioners agree, we'll put that out to public comment. But a second thing is how do we promote greater competition to bring down some of those fees in the fund management space? And I think that being clear on the naming and what it stands behind those names can also help in the competition on the fees themselves.
Well, as you move forward with your climate risk disclosure rulemaking, I just want to stress the importance of this materiality standard and what it actually is, because to rely solely on the comments that come in, I think, and just ignoring what the legal definition of materiality, I think would miss the mark, because materiality is about investors' need, the actual need for that information to make informed capital allocation decisions. It's not just about large institutional investors' desire to name and shame politically incorrect companies. So I encourage the commission to look at materiality from the traditional conventional legal standard of what materiality actually means. In terms of liability protections, I do worry about the subjectivity of this, the concept of climate risk disclosures relying on subjective and untested metrics. Do you have plans to provide liability protections for issuers? What are your plans to ensure that these disclosures are preserved exclusively for informing investors and making their risk-reward decisions and not hijacked by enterprising trial lawyers for frivolous lawsuits?
Well, like all of our disclosures, they're based upon, as you say, what do investors want? What do they take into considerations? Or as the Supreme Court has said, what's if I remember, substantial likelihood that a reasonable investor finds significant in the mix of information for an investment decision. And that investment decision is really the important thing. And that's why we put it out to notice and comment. Investors get to weigh in.
Thank
And
you. The gentleman